Sarah Boone represents herself in court today, and this happened.
That's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question.
Thank you.
Now, I don't expect her to know because as a normal person, you wouldn't know. If you're an attorney, if you're practicing law, of course you're going to know what sustained is. So this is why I wish Sarah Boone had representation. I wish she wouldn't fudge it up with the other previous attorneys, or maybe it really was their fault according to Sarah Boone. But this is why I'd rather just have people have representation because it makes things longer. Things are more delayed.
I know that you had brought up concerns regarding mailing, and I just wanted to go through.
Yeah, she needs a table too, because her using her leg, like, I don't know what's going on with this setup here, but I'm sure they're going to have it all set up for her, hopefully for next time, and for trial for sure.
Historics with regard to the mailing. As you may recall, back on June 28th, we had a hearing where I granted Ms. Cushman's motion to withdraw and addressed your forfeiture, alternatively a waiver to counsel.
The judge is going to go over all the mailings with Sarah Boone and also things that were hand delivered to her because Sarah Boone made a complaint that y'all had the wrong address. You're mailing things and maybe you're withholding things from me. She made that accusation. So the judge is going to go over all the things that was mailed to her or given to her in hand, just to make sure that what she's accusing them of, which is withholding stuff, is actually not true. Now, there was one thing that was missed, but they said they corrected pretty quickly.
So I know that there was a concern with regard to mailing and things purportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery, and that was remedied the exact next day on July 30th. So that
and that was mentioned previously because she was saying that things were being mailed to the wrong address. The judge addressed that in the last hearing, saying that, like, yes, we found that out. It was a clerical issue, and we remedied that pretty, quickly.
clerical error as to the wrong address was remedied.
Oh, okay. I swear to God, I didn't watch this hearing yet. He's literally saying what I just said. I should just wait.
One day after the original order was sent out on July the 29th. I just wanted to put that on the record and, again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required.
And that's why I was thinking he was putting all this on the record, because he just wants to make sure that she doesn't come back to the judge or anyone else to accuse him like, oh, you guys are withholding things from me. So that's why I was thinking why he decided to go through all the dates and all the stuff that was sent to her, mailed to her, given to her in hand, just to make sure she can't accuse him like, oh, okay, you guys are doing something shady in the background. And now Sarah Boone is going to disagree with the judge. However, whenever the judge asks her specific, Sarah Boone struggles to give the specifics. I don't know, it's because she either forgets, she doesn't write it down, or maybe she's not correct.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to P.O. Box 9101.
I don't know what you're talking about.
You were talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order.
See, the issue with Sarah Boone and her argument so far is that she needs to be very, very specific. So when she's referencing there are 3 documents that was mailed to the wrong address, blah, 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 she needs to be like, okay, it was this document, it was this document, it was this document. She can't be vague and be like, oh, it was just 3 documents. Maybe she'll get there. Maybe she'll explain it in a little bit. But I feel like every time when she goes back and forth with the judge and the judge is like, okay, who said that? She's like, she doesn't say. She needs to really be ready to answer the judge the specifics that she's talking about instead of being vague. And that would really help her a lot.
But I can't tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail.
The state, Mr. Cacciatore, who actually was the guy that was wearing the trench coat in the last hearing, he has a USB drive that has the exhibits, witness list, proposed jury instructions, and victim ID and some other stuff that they're going to give to Mr. Lane, who is the PI in this case for, I think his company's like Prison Breakers. What a name, huh? He's going to give that to Sarah Boone. So this is exchange is happening right now. However, Sarah Boone talks about an issue that she has, maybe some tech issues with her laptop and viewing some of the discovery from the previous USB that was given to her.
Mark that as an exhibit for the purposes of the hearing. I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay. Any other questions? Yes.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files, so I cannot open a majority of what are on both of the USB drives.
And I wonder if she just doesn't, maybe they're large files and she doesn't know how to like unzip them, or maybe she doesn't have the program to unzip some of these files.
What do you mean you cannot open a majority? What can you not open?
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats, but there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay.
So I don't know.
What does it say?
I don't know.
Yeah, and this is where she needs like the specifics. Like, what does it say specifically? Does it say like, oh, cannot open, file corrupted, file like type not supported?
I moved on from that to try to go to other programs, so I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. That's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Okay. And how many times has that happened?
The one time
One file, 10 files, 20 files, 50 files, or was it just a one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what for the most part means.
I haven't had time yet to explore everything due to the dorm environment. So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you, so you know what I'm trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
Okay. All right. Dave?
Tech issues. I'm not surprised that she's having tech issues. And also, I don't think she has internet at this point. So if she wants to fix something, look something up, or how to fix it, she won't be able to. Or if she needs to download any programs to possibly open these files. I don't know, man. Sarah Boone, this is a tough one for you. Whew.
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she
probably doesn't have a VLC player.
Clicks on that folder, she can click again on a subfolder, and she will find the VLC files for where the Publix video has been converted. So everything in there should be standard JPEG, VLC, and also believe an MP4 for some audio-only files.
Okay. All right. Ma'am, do you have any other questions with regard to the digital information or digital?
But see, I don't know if she has access to the internet like that to download a VLC player. I don't think so. She probably has like, if she does have access to internet, it'll probably be like super restricted. And I don't know if she'll be able to like download things.
Evidence identified.
I was thinking about VLC as well, because I feel like every time when I have issues with my video editing or previewing and stuff like that, it's always the VLC shit.
The notice that the state's provided the court and yourself this morning.
That was what was just handed to Mr. Lane. So, Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that.
Now, remember Sarah Boone, she wanted to have hard copies of her documents. So they're going to give her digital copies of the 2 boxes of discovery, but she wanted the hard copies. That way she can view them outside of the 9 to 4 hour that she's given the laptop. She wants to be able to view them when she's not, time restrained. And, that makes sense. But initially the jail was like, we don't have room for this. We don't know where to keep this. It was a no. But they're able to give her the hard copies, which I think it's good. However, she just has to make sure no other inmates in there are going to be able to mess with it, and she's going to be able to organize it, make sure it's not sabotaged. And then honestly, I feel like she's the type of person, if she thinks someone sabotaged it, she might blame the jailhouse. Like, oh, someone came in and messed with my stuff. I don't know.
Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property and the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, H-A-L-L, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you.
So it is Tracy Hall?
Do you know Miss Hall's first name?
I don't know any of the officers.
Okay, all right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can. Yes.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide...
It kind of sucks that like he can't just give it to her right here because she's like right there, you know. It's like they have to do this whole procedure thing. It has to be formal. It's like, can I just give it to her that she's right here? You know, it's like no.
To him, the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously, and Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this, State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case.
What I'm also wondering is, does she have a bunkmate? I'm assuming you probably do, unless she got really lucky and she's like in a room by herself. Because if she's with a laptop from... was it like 9 to 4, 8 to 4, something like that? I'm sure she's like, didn't they say they're going to have like a separate area for her to be able to view these files? But once that time frame is over and she wants the hard copies with her, wouldn't she still be surrounded by other people when she's viewing those hard copies? And then like to make sure it's like organized, to make sure people don't like go through your shit, things get lost.
Ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence.
The court now addresses Sarah Boone's motion for freedom of movement. And when we hear that, I'm thinking, okay, so when she wants to do the trial stuff, she wants to be able to move freely as if she's a regular defense attorney. Now, the state, they're going to oppose this, and they're going to call 2 witnesses to explain. Well, one is going to explain why they oppose it, and then the other witness, we'll get to that.
Are you familiar with the defendant in this particular case?
Just through research that I've done on her. I don't have any personal knowledge of the defendant.
What kind of research have you done on her?
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings, or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings.
That's kind of interesting because he's saying that there's 3 separate times where she didn't want to appear into a court hearing. But I mean, all that we've heard from Sarah Boone is, I want to attend every single hearing. I want to be there for all the motions. Include me in, include me in.
Hearings. Those kind of, she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you combine all that, I mean, it shows a propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
I don't know. What do you guys think about that? I don't know.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have.
Oh yeah, no, I'm not going for like have her like free, like just free roam everywhere and not be shackled in any sort of type of way. I'm just saying that, like, you know, maybe like no handcuffs and then have her maybe like her legs shackled to the table or something. Give her some like kind of like one of those like long doggy leash, you know, give her like maybe like 8 feet or something. Dara Brooks had the shock shackles, right? But for Dara Brooks, were the shock shackles kind of like a last resort thing for him because he was acting up so much? Or did he already have the shock shackles from the beginning? Because I remember he kept saying shock shackles.
Handcuffs on. We've modified.
Restrained during trial.
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's making motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Yeah, I agree with the leg restraints.
Your Honor, I don't believe I have any.
Oh, was that the meme actually? I don't think he ever actually had shock shackles. I think he just thought that they were. Hold on, I think I'm getting confused. There were no more shackles. He supposedly said there were shock shackles in front of the jury for sympathy. Oh my goodness. Because I remember he kept saying shock shackles. Now remember, because Sarah's representing herself, she's going to be able to question the witness directly. However, she doesn't know how things are done. She's going to try to disagree, of course, with the witness and giving her personal statements in there.
First off, in your in quotes research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Objects to the form of the question, Your Honor?
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
Okay.
I am prepared to give her the dates. Okay. On September 15, 2023, that was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in
At
court?
the jail, yes.
Who is your contact, please? I've never missed a date.
This is a database that I got this information from.
Do you know when it was last updated?
I don't know.
Okay, so do you know how I have never missed a court date to the present date? I don't know specifically what these 3 dates are for. In order for me to have supposedly denied going, do you know the name of the officers for each one? You do?
Yes.
Please.
For September 15, 2023, it is Corrections Officer Portia Hines.
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay.
And if you would like, I can read her comments.
a year ago.
Report.
Sure.
Because I thought maybe some of these dates were maybe like in the very beginning when she was in jail.
Midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It doesn't say specifically what your hearing is for.
Okay.
Second one, it'll be Officer Christy Green.
And what is this date for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's going to be October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
2023, and these were the times where she was like, I want to attend every hearing, every motion. I want to be there for everything.
And what was the...
But remember, the letters that we were getting from Sarah Boone, it's all one side. It's from her perspective. We don't know what the attorneys were. We don't know their perspective because they can't say shit, right? All the other previous attorneys that she had.
Initial, please.
K.
Green.
October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
And what was the first initial, please?
K.
Greene.
Yes.
10/16/23.
Yes.
Okay.
And the third one is January 28, 2021. And the officer is Jasmine Scribner. Scribner.
What are the comments, please, for Green?
At approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward in the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay. And January 28?
Approximately 0334 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information down.
Okay. So I'm trying to figure out how I know all three corporals and the sergeant, so I've never refused court. There's no reason for me to want to refuse court.
Yeah, because this makes her look bad because, we've seen her letters, how many times she says, I want to attend everything. They're not letting me attend, blah, 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 blah.
Just to ask and answer.
I'm going to sustain the objection.
So the domestic violence, the original, was dropped. I was never charged with that.
Object as to relevance, Your Honor.
Overruled. You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate, so they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate, so they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
Your Honor, I'm going to object to the question.
Objection sustained.
New
Both
question.
of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm going to object
That's not a question.
to the form of the question. It's not a question, it's a statement.
Sustained.
Forgive me because I don't know what I'm doing.
You gotta
I'm
ask
trying
questions.
to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way, apparently, so I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand your position. I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation. That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that is in your history.
I understand, but I was never charged with it, correct?
You were charged with it. It was dropped. The charges were dropped.
But it is not on my record.
The rest is on your record.
But the charge for the domestic violence is not on my record.
No,
I'm
you were
going to
never
object just to
convicted.
ask and answer, Your Honor.
Overruled.
You were never convicted of the domestic battery charge, but you were charged with it.
And the case was dropped.
Yes.
For the three supposed non-compliance that I have, I know that 2 of the officers are no longer with the Department of Corrections. Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it a...
Your Honor, I'm going to object to the form of the question. This is a statement, question.
Objection is sustained.
I think a lot of this is going to happen because she's going to be very, very tempted to correct what the witness is saying on the stand. She's not going to like their version of the story, so she's going to try to correct them and give her version. But it's like, you can't do that. You got to ask some questions, man. And this is the reason why the judge, in my opinion, this is the reason why he extended the trial date from 2 weeks to 3 weeks. He's like, oh, she's going pro se. She has to go pro se. We're forcing her to go pro se. We're going to extend it by another week because it's going to be a lot of, her not knowing the process and stuff.
I guess I will provide information to you for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
What do I need to provide to you in order to have that remedied, in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
Go ahead.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's that?
The decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Right, but just to clarify and conclude, I was not ever charged with that.
Again, I'm going to object as to ask and answer.
Sustained.
Okay, I will, do I provide this information to you?
You can provide it to the state.
Okay.
Oh boy.
Am I, in your opinion, a flight risk or detrimental to the courtroom and am a threat of any type of harm?
Flight risk? What's this have to do with flight risk? We're not trying to get you out on bond.
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraint.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018?
Correct.
And it is now 2024. Okay. And you're going solely off of what, the arrest affidavit?
Do you guys remember how long she was with George? 4 years, I think I heard. Was it from 2016 to 2020? Or was it longer than that?
What is it that you're using to conclude due to this occurrence that was dropped that I would not be able to be unrestrained?
Correct. Your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
But what specifically from that 2018 charge?
The fact that you were charged with battery by its regulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
But it was never proven, correct, because it was dropped?
It was dropped. Doesn't mean it didn't happen.
Okay. I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates, the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is. So,
And you can still apply it even though it's not been?
Correct. It's in your history.
Okay. Thank you for the information.
You're welcome.
Any follow-up, Steve?
No, Your Honor.
Fine. Thank you, sir. Anything else, Steve?
Not from the state.
Okay. Or good afternoon, or good morning, rather. Can you state your...
I don't know if jail shoes are Crocs, but sometimes I do see inmates when they come in, they do look like Crocs. So I don't know. Maybe they sponsored or something. I'm just kidding. This next deputy who's going to testify, he's going to talk about other methods of having Sarah Boone being able to walk freely in the courtroom. However, what they're going to give her is something called a stun cuff. It's an electronic, wireless. They said it's secure to one of her legs. It's going to be at the calf. What's going to happen is if anything happens, if she gets violent, if she tries to escape, she's going to get 50,000 volts to her calf leg, which is probably going to cause her to fall down, and it sounds very fucking painful. So that is the proposed alternative for Sarah Boone, and I think she's going to agree with it. However, before she does, though, there is some back and forth with the judge, which like I said, I didn't really understand where she was going at with this. Maybe I just didn't understand her point. It just seems a little bit frivolous.
So that is an option.
Yes.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before
I would assume she'd be given civil close
that can actually be
for trial.
made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the local court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification. Because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise...
I mean, at this point, you might as well just do the freedom of movement where you can move around the courtroom and stuff like that. I thought that's what she was asking, too. I thought she wanted to move around freely as if she was like any other attorney in the courtroom.
Shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go with having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go with having no counsel, because...
Remember, she said that I have freedom of speech. I could have said whatever I wanted, but the court is impeding my freedom of speech because, I can't say whatever I want because that led me to not having counsel. Remember when she was writing her motions, she was saying that like, oh, it's freedom of speech, freedom of speech. I was just expressing how I felt about my attorneys, blah, 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 blah. Oh, gosh. She was doing so decently,
Wanting to be unhandcuffed. Is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go with having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. But you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably free in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So
and that's how I interpret it too. And then also, I don't know, it's kind of, if anything, the judge is giving her more than what she asked in her motion. Although in her motion, it seems like she wants freedom of movement within the courtroom, right? Like any other attorney that comes in and practices and defends her client. But then she's like, well, you didn't really ask questions because you would have known all I wanted was just to have my hands to be free. I'm like, where are we going with this?
If you would like to clarify for me now at this time, you can, as to what it is that you're asking of me.
Yes. Handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
go ahead.
It's just handcuffs mean unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all in the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that
What about the shock thing that they were talking about earlier, the stun cuffs?
Unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not, so that, again, that was why I was trying to be transparent and up forward by doing so now to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial,
Okay.
yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is.
You said that?
For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Okay, thank you. Anything else you'd like to tell me, ma'am?
I think that's the direction that the court was going by, you know, we had two people go up there and testify. One was like, oh, she shouldn't be moving around freely. The second person goes up there was like, okay, we can do stun cuffs. I think that's the direction that they were going, it seems.
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at the counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set for today, to address all those circumstances and again think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed to be able to progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole. with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me, are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle.
Oh, jingle jangle. Oh, trust me, she's not going to let them forget. She's going to forever remind them, it's not my fault I'm in this situation. I didn't choose to be in this situation. This is your fault. Judge, previous attorneys who are representing me, and they were doing a horrible job. It's all their fault. Not my fault. I didn't want to be in this position.
Or bringing noise attention. The privacy panel is located in front of defense counsel's table, would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, you're just address all the concerns, which is the court's plan.
Got it. All right, thank you very much.
For pretrial stuff, the judge is going to allow her to be unhandcuffed so she could write her notes, which I agree, because she should be able to, especially since she's sitting there, she's like learning everything on the fly, she's got to be able to take good notes, whatever. And they are going to have her, like, you know, her ankles are going to be restrained. However, for the trial, like I said, they're going to have her unhandcuffed. She's not going to have ankle cuffs at all, or like the belly chain cuffs thing, whatever you want to call that. She is going to have the stun cuff. Is that what it's called? Stun cuff? Yeah, they're going to give her the stun cuff thing. So if anything happens, you know, she's going to get stunned, and 50,000 volts of electricity going to her calf. Ouch. But that is what they decided. And as for whether or not she needs to go back and forth between moving from where she's at, the defense table, to, let's say, to the witness. If she needs to give any exhibits to anyone, she's going to hand it over to the deputy. And, you know, that sounds fair to me. I think if you guys listened, they also mentioned how, I don't know if I included it, but they're going to figure out a way to have it so it's like muffled. So if she is moving around, they're not going to hear, like, you know, the jingle jangles, or I don't know if the stun cuffs has noise that it makes while you're moving around, but they're going to make it so, you know, when she's out there representing, the jury won't be able to tell that she's like cuffed or anything like that, or she's got the stun thing on her. So yeah.
Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
Thank you.
State anything to clarify?
No, you're not.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024, a representative from the Orange County Jail shall email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of the laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today.
Okay.
Is there anything else, state, that we need to address?
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Yes, ma'am.
In regards to the status report you were just speaking about regarding them providing me with a laptop each day, what is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate P.O. box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, well, my concern was they're not stating what it was that I looked at for how long and
I don't know that
anything.
they're going to record that information on the protocol, ma'am. It's
Okay.
just simply when it's checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of,
How would they know what she was looking at, like what files she opened and for how long she was viewing it for? Like,
of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence, and I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning, and that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state's physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. in courtroom 12A, Orange County Courthouse, and then the address of the courthouse. So the physical evidence will be reviewed at that point in time.
What about the
Yes,
media?
Your Honor, I understand. My question, though, was, are you still trying to decide or research having the media here in the
Yes,
courtroom?
ma'am. I've pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space, and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th?
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problem. It's the Miami Herald decision. I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank you.
And that will be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent of showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the
The
evidence from
digital
the
evidence.
state
The digital evidence only.
of the 2 USB drives from Mr. Lane?
Oh, no, ma'am. The USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections?
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in order for you as well, ma'am.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No, Your Honor.
Ma'am, is there anything else?
I do have this. I made a copy of it for you. This letter that
Oh God, sorry. Let me turn the audio down. I don't know what's going on here.
I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags, and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet, if I could be supplied earphones and headphones for listening. And
Oh, was she not given earbuds or earphones, headphones? Oh my gosh. Wait, why did they not give her earphones? Wait, hold on a second. Oh, she's talking about in her bunk?
I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet, if I could be supplied earphones and headphones for listening, and a word program just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives, and just, as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Ma'am, well, you can give your letter to the deputy. We will file that in the court file. Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain DiGiovanni was returning on August the 12th from a vacation.
And even if she did have internet, have you guys ever had internet that was very limited? There are some websites where I'm just like, wait, why can't I access this when I should be able to access this? I don't know. Like having limited internet seems like a fucking pain in the ass, especially if you're going to represent yourself and you're going to research all this case law and stuff like that. Like, oh gosh, I don't know how she's going to do any of this. This sounds so hard. She's like on hard difficulty level right now.
Vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on the media request, or prevent media from being at the September 3rd discovery viewing hearing, will address your concerns as identified in this letter, and have a representative from the jail, be it Captain DiGiovanni or someone else, here to address those concerns.
Thank you. And if I may,
Also, they need to set up with the VLC program too.
Giovanni or someone else here to address those concerns.
thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded inspecting and testing and photographing, I believe that is my business only, and one bit of privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence unit, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
Oh man, I don't know if she just has like memory issues, or maybe there's just so much going on, or maybe she just wants to be like extra careful and make sure she wants to like extra clarify things over and over and over again. But I'm like, you're writing all these notes. Are you rereading your notes when you're back in your cell? Or on your bunk bed or whatever it is that you're staying at? But I don't know. It's a lot of like repetitive stuff over and over again. And I get wanting to be super clear cut on things, but I don't know. Sometimes I'm just like, she's taking all these notes. I don't know if she's like really going back and rereading them, reviewing them to making sure that she understands what the hell it is that's going on.
No.
Okay. I will see you all on August 14th at 1:30.
Next Wednesday.
Ma'am, as the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet.
Oh, nice. They're going to give her the pro se pack and just help her out a little bit.
I have a hard copy for you, and I'm going to have Ms. Barrios also send you a copy by way of mail. It was already mailed.
Good.
Okay, we're going to mail you a copy as well, ma'am. Today, I'm going to give this to the deputy to provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
Yes.
I wonder if they can give her like those books where it's like, I don't know, pro se for dummies or something, representing yourself for dummies, like just so she can know like basic keywords, terms, how things flow in a criminal court case, you know, and trial and stuff like that. Yeah, I don't know. Like opening statements, you know, and closing statements,
Yes, thank
arguments.
you. And then
Ugh.
That the JAC attorney made reference to on our hearing on August 5.
yes, thank you. And then also the public defender's office, you said, would be meeting me downstairs.
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave?
No, Your Honor.
Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail.
Thank you.
Okay, so that's going to be next Wednesday, a couple days from now. You know, maybe someone just send her some books or something just to make sure when the trial happens, it goes a little bit smoother.
Bruce.
I'm not opposed to that.